We are live. All right. I welcome all the viewers, wherever you are around the world. Good morning, good evening, good afternoon, depending on which location you are in this part of the continent. Just a minute, I'll be with you. Right, in today's... Sorry for that. All right, once more, we welcome all of you, our viewers, millions of you, wherever you are, and indicate that today we have a session that's going to address the international criminal tribunals, military tribunals. It is in honor of the efforts that were made by the predecessors of the current international criminal justice process and system about 75 years ago. So as we mark the 75 years of the existence of the events that occurred during the International Military Tribunal of the Nuremberg, we want to analyze some of the aspects of those tribunals and what transpired. With you today to present for you, we have Professor Dwarakanath Tripathi, who is a professor of international law of several years, well over 30 years, and is here to be able to present his views on this particular topic. I hope you'll be able to benefit from him. We also have with us Mr. Brian Kutlo, counsel, and we hope that his contribution will be able to afford you some understanding on the issue of International Military Tribunal. We have other members of the panel who might be joining us in the course of the proceedings. And on that note, I wish to welcome Professor Tripathi. If you have anything to present, the floor is for you, Prof. Proceed.
Thank you, Professor Milton, for giving me the first opportunity, as always, to speak on today's theme of the discourse, that is the Nuremberg trial. And I welcome all the viewers of this program, wherever you are. And I also welcome my other colleague or expert, Brian Ramapane. Now, coming to the very theme of the Nuremberg trial, we are all aware of the Second World War that took place from 1939 to 1945. Prior to that, international criminal law in the world did not have much significance, in the sense states did not care about what happened in other states. But after the First World War, which took place from 1914 to 1918, in 1919, the Treaty of Versailles was signed, and under the treaty, in 1920, the League of Nations was established. The League of Nations was established for the purpose of maintaining international peace and security in the world. That was the foremost purpose and objective of the statesmen of the world then. And after the establishment of the League of Nations, the states felt that they should sign a few treaties and conventions in order to lend support to the League of Nations and its purpose of maintaining peace and security in the world. And therefore, a few treaties and conventions were signed. And there was, in fact, a landmark convention that was signed under the framework of the League of Nations in the year 1937. This convention was on the establishment of an international criminal court. The first effort that was made by the states in between the two world wars, there was an effort made by the states to establish an international criminal court. But while the convention was signed, the court could not be established because in 1939, the Second World War started. Now, prior to the starting of the Second World War and after the start of the Second World War, that is in 1939, there were a series of events that were held by certain states who were keen on establishing another international organization that would be able to maintain international peace and security in the world. And one such first event was in 1941 itself, when the World War was going on. The heads and representatives of 9 exiled governments met at St. James Palace in London, and they signed a declaration. And this declaration came to be known as the St. James Palace Declaration. In this declaration, they had only one agenda, that is to establish peace in the world. So it was a landmark event. And then next came the Atlantic Charter, 1941. The two greatest statesmen of the world then, Prime Minister Winston Churchill of England and then Franklin Roosevelt of the United States, who was the president of the US at that point of time. They both met on a ship sailing on the Atlantic Ocean. And that is why the charter that they signed was given the name Atlantic Charter. And the purpose of signing the charter was to end Nazism in the world. That was the single agenda of the charter, to end Nazism and to establish peace in the world. And then followed the Moscow Declaration and then the Tehran Conference. After the Tehran Conference, we had the United Nations Declaration. Now, the United Nations Declaration holds a very important and significant place in the sense you might wonder, even before the establishment of the proposed international organization, how did the states use the words United Nations? That is, for the first time in the history of international law and in the history of establishment of international organizations, the words United Nations were used. And eventually, these words United Nations were given to the international organization that was established in 1945. That is how the UN came to be known as the United Nations Organization. So this declaration, United Nations Declaration, is a very important declaration. And then we had the Dumbarton Oaks proposals or conference, where the conference was held in two phases. In the first phase, we had representatives of UK, USA, and Russia. And in the second phase, we had representatives of the UK, USA, and China. And the Dumbarton Oaks conference is also a landmark conference because the uh, structure of the organization that was proposed to be established in 1945 was discussed in these two phases. The composition of the organization, the number of organs that the organization would have, the functions of the organization, and the powers and the jurisdiction of the organization. All these issues were discussed during the Dumbarton Oaks Conference. And then we had the Yalta Conference, where some of the issues that were not settled during the Dumbarton Oaks Conference were settled during the Yalta Conference. After the Yalta Conference came the San Francisco Conference in 1945, when the United Nations Charter was adopted by the states. And the states that were that together adopted the charter were 51 in number. These 51 states are said to be the founder members of the United Nations Organization, or we can also call them as original members of the UN. All the other states, now the membership of the UN is around 194, but these 51 remain the founder members of the UN. All other states have joined the United Nations Organization through a system known as accession. That is, they have to deposit an instrument of accession. Accession is to accede, attached to the organization. So an instrument of accession is deposited by the state, accepting its obligations under the United Nations Charter, and that is how it becomes a member of the UN. Of course, under Article 4 of the United Nations Charter, the UN has laid down certain conditions for a state to become a member of the UN. But let us not go into that because that is not important for us now. Now, after the establishment of the UN, in 1945, in the same year, the Second World War also ended with the bombing of the two Japanese islands, Hiroshima and Nagasaki, by the United Nations, by the United States, which signaled the end of the war. And in the same year, the two tribunals, international military tribunals, were established. One was known as the Nuremberg Tribunal, and the other was known as the Tokyo Tribunal. The Nuremberg Tribunal was established in Germany mainly for the purpose of trying war criminals of German nationality. And the Tokyo Tribunal was established in Japan for the purpose of trying the Japanese war criminals. Now, coming to today's theme, that is Nuremberg Tribunal. The tribunal was established immediately after the end of the Second World War, and it was established mainly for the purpose of trying war criminals of German nationality, which I already mentioned. Now, the victorious powers signed an agreement and established a charter known as the Nuremberg Charter. And this charter empowered the Nuremberg Tribunal to confer jurisdiction. The charter conferred jurisdiction upon the tribunal, and the tribunal was also authorized by the charter to try and punish persons guilty of war crimes during the Second World War, and it also further conferred jurisdiction on the tribunal in respect of crimes against peace and crimes against humanity. Now, you will find all these crimes under the statute, the Rome Statute of the International Criminal Court. So, what is significant about the Nuremberg trial is that it was the first international military tribunal where international crimes which were committed by international war criminals were being tried. It was the first instance where the heads of states now were brought to justice before the courts of law. It was the first instance where liability for crimes committed by heads of states was being attached to those heads of states. So it was a landmark trial. Now, the trial of the main accused began on November 20th, 1945, and the judgment was delivered on September 30th, 1946. So, in this period, the trials were held and the accused were found guilty and punishments were accordingly given. Not all the accused persons were punished because the tribunal acquitted 3 accused persons. It sentenced to death 10 accused persons, and it sentenced 3 persons to transportation for life, and then 4 persons for imprisonment for life, and 4 persons for a long period of time. So, in this manner, the trials were held, and according to the uh, gravity of the crimes that were committed by the accused, the sentences were given accordingly and they were punished. The main charges against the accused were that they had committed war crimes, crimes against peace, and crimes against humanity during the Second World War under the leadership of none other than Adolf Hitler. The accused had committed inhuman crimes and crimes unimaginable by mankind. The accused were also charged of violating the Treaty of Versailles 1919. Now, this treaty, which I mentioned, that is, the League of Nations was established under this treaty in the year 1920, the Treaty of Versailles. And the main objective and purpose of the League of Nations was to establish peace and to maintain peace and security in the world. So, they were charged of violating the Treaty of Versailles, that is 1919, as well as the Pact of Paris 1928. This Pact of Paris 1928 is also known as the Kellogg-Briand Pact. What is important of as far as the Pact of Paris is concerned? Because the states which signed this Pact of Paris, the state parties, renounced war as an instrument of national policy. They said they would never fight a war again. They will never use force against another state. And they all signed the Pact of Paris. So Germany was accused of violating this Pact of Paris by uh, starting wars against the neighboring states. Now, if you remember the facts correctly, on September 1st, 1939, Germany attacked Austria and Poland. And on September 3rd, 1939, England and France declared war on Germany, and that was the beginning of the Second World War. So, Germany was accused of violating the Pact of Paris, that is the Kellogg-Briand Pact, and the the pact clearly laid down that the state parties had renounced war as an instrument of national policy for the settlement of disputes. Now, one must remember what could be the reason, what could be the factor that would prompt states to go to war. Why would they fight a war? The main reason is a dispute between the two states. So, what the Pact of Paris laid down was the states should not resort to war. They should settle the disputes peacefully by employing the Pacific method of settlement of disputes, which are known as arbitration, mediation, conciliation, good offices, all these methods, and judicial settlement. So these methods must be used by the states to settle the disputes and not to resort to war. And that is why uh, the nation of Germany was accused of violating the main purpose or objective of the Kellogg-Briand Pact or the Pact of Paris. However, during the trials of the accused person in Nuremberg, the Nuremberg court laid down certain principles, and these principles later formed the basis for the establishment of the International Criminal Court in 2002. Now, what were the principles? The first principle is crimes against international law are committed by men, not by states. And therefore, uh, it is only by punishing men that provisions of international law can be enforced. So we also see a similar statement as far as the International Criminal Court is concerned. Now, the prosecutor's office is very clear, saying that we do not accuse states. We do not prosecute states. We prosecute individuals who are guilty of committing crimes. So that stems from this principle, which was laid down during the Nuremberg trial, that it is the men who commit crimes and not the states. So by punishing men, the provisions of international law can be enforced properly and effectively, and that would have a deterrent effect on the heads of states in the future. However, that did not stop the heads of states from committing war crimes, because we have seen examples of Rwanda, Yugoslavia. It never stopped until the establishment of the ICC and the two international uh, military tribunals, one for Rwanda and one for Yugoslavia, that were established by the Security Council, were landmark tribunals, because the tribunals punished the accused persons. And that kind of put fear in the minds of the heads of states that now, after committing the most grievous crimes, they cannot escape liability. They will be brought to justice. But despite all this, there were certain instances where the heads of states continued to commit crimes. We have seen uh, Robert Mugabe in Zimbabwe. And then we also had Sierra Leone, where there was a conflict. Then Sudan, there was a conflict. Then Libya. So these continued despite all the steps and measures that were being taken by the international community to control and prevent the commission of war crimes by the heads of states and those persons who are in power. Then the court also laid down the fact that a person who commits such an act, which constitutes a crime under international law, if he happens to be a head of a state, that is not going to absolve him of liability. The same principle has been adopted by the statute of the ICC, the Rome Statute. If he's a head of a state, the immunity will not help him. He shall still be punished if he is guilty of committing war crimes, genocide, and crimes against peace and crimes against humanity. Now, speaking of genocide, genocide was one of the most uh, important crimes that were committed by the Nazi war criminals during the Second World War. Uh, genocide, the term genocide was coined by one international jurist by the name Lemkin. And what is genocide? It is nothing but the mass liquidation or extermination of a race from the face of the earth. So it's a grave, in fact, the gravest violation of human rights, eliminating a race totally. And that is what happened during the Second World War, when the German Nazi uh, war criminals killed thousands and thousands of Jews by either putting them in the gas chamber or putting them before the firing squad and shooting them to death, or they were hanged, and some of them were burnt alive. So these were the kind of crimes that were committed during the Second World War, and all the persons responsible for these crimes were brought to uh, justice before the Nuremberg Tribunal, and that is what, even if a person who is guilty of all these crimes happens to be a head of a state or a government servant or a government official, will not absolve him of liability. He shall be punished. Similarly, the court also further laid down the fact that a person who acted in pursuance of orders of his government or superior, that is, responde superior principle. Now, the accused may say, I was helpless. My senior military officer ordered me to kill. I killed. But the court did not accept this. What the court said was, if the person had a choice not to commit the crime, then he should have taken the choice of not committing the crime. If he commits the crime, he shall be liable. So, this principle of responde superior also was not accepted by the court. The court clearly said that if you had a choice to go against your superior officer and not to commit the crime, you should have taken that step. But simply believing or accepting the orders of the superior and then committing crimes will not help. And the persons were punished. And the tribunal considered the conduct of aggressive wars as the highest international crime in the world. That is, in the eyes of the Nuremberg tribunal, the act of conducting aggressive wars against other states was considered as the highest international crime that can be committed in the world. And Germany was responsible for starting aggressive wars, which were against the Pact of Paris, that is the Kellogg-Briand Pact of 1928. As I said, on September 1st, it started wars against Poland and Austria. Therefore, the persons responsible for organizing or conducting these kind of wars were guilty. The court held that planning and preparation were essential elements of the conduct of war. If it was found that the persons who were found guilty had very efficiently planned and prepared for the war, then these two, planning and preparation, would constitute essential elements of the crime of war, and they would be held liable and found guilty. Now, the court also held the accused guilty of badly treating the prisoners of war. During the Second World War, the prisoners of war were taken by Germany. So they were also accused of treating badly the prisoners of war, because we do have a Geneva Convention on the protection of prisoners of war. Of course, the Geneva Convention uh, was signed in 1949, but the accused argued that they were only uh, torturing the Russian prisoners of war. And they also pointed out that since Russia was not a party to the Geneva Convention on Prisoners of War, they cannot be tried for that offense. But the court rejected this argument and stated that even if Russia was not a party to the Convention on prisoners of war are humans, and you have committed a crime against humans for which you will be held liable. You cannot escape liability. And then crimes against humanity. We have a series of crimes that were committed by the German armed forces during the Second World War, and they were all held guilty for crimes against humanity. And finally, the judgment of the Nuremberg Tribunal occupies a very significant place in the law of war in general and war crimes in particular. Some jurists have justified it because they felt that the war criminals had committed the gravest of crimes in the world. And if they were punished by the Nuremberg Tribunal, the tribunal was fully justified. That was the opinion given by some of the jurists. And that is, since the accused have committed war crimes, crimes against peace, and crimes against humanity. Now, while there was appreciation from some of the jurists in the world. There was also criticism that followed against the Nuremberg Tribunal. That is, some of the legal experts in the world have criticized the tribunal on certain grounds. Now, what was the first ground? The first ground was that the Nuremberg court laid too much focus on the Pact of Paris 1928. No doubt, the Pact of Paris had renounced war as an instrument of national policy. But where was the need for the court to lay so much of emphasis on the Pact of Paris 1928? Those states which were not party to the Pact of Paris can always resort to war. So, on this ground, the Nuremberg court was criticized by some jurists. Then, the Chief Justice of the United States Supreme Court at that point of time, Justice John Marshall, pointed out that the Charter of the Nuremberg Tribunal declared those crimes punishable which were not punishable at the time they were committed. That is post facto laws. The acts committed by the German armed forces at the time of committing those acts were not crimes. They were declared as crimes subsequently. So, how can a person be tried for a crime that has been declared as a crime and not at the time when the act was committed? Because this is against the principles of criminal law. So, Chief Justice John Marshall had clearly pointed out that this has been a drawback or setback for the Nuremberg Tribunal. Now, some of the principles which were incorporated in the charter, that is the Nuremberg Charter, were contrary to international law. The plea of superior orders was rejected without any reasonable ground. Some of the uh, German officers, military officers, were under complete pressure from the superiors. If they did not kill the enemy, the superior officers would kill them. So, what would one do in such a situation? So, they followed orders and killed. So, this fact should have been taken into consideration by the Nuremberg Tribunal, but it was uh, rejected. That is, on unreasonable grounds. The plea of superior orders were set aside and the accused were found guilty. So, this was another ground that was criticized by the legal experts. Now, one more ground is that the Nuremberg Military Tribunal cannot be considered as an international tribunal. They gave it the color of an international tribunal, that is, International Military Tribunal was the term used for the Nuremberg Tribunal. But some of the experts pointed out that it cannot be an international military tribunal merely because of the fact that the judges of the tribunal all came from the victorious powers, the four victorious powers, that is, most of them. For an international tribunal to be called as an international tribunal, there should be a kind of a universal representation from some regions of the world. The judges must come from all the regions of the world. Only then the tribunal can be called as an international tribunal. But in this case, the most of the judges came from the four victorious powers, and therefore it cannot be called as international tribunal. So this was also a kind of a setback for the Nuremberg Tribunal as it was criticized. Now coming to the legal significance of the Nuremberg trial, what kind of lessons does the tribunal uh, and the tribunal had passed to the uh, future course that would be taken by states when war crimes are committed. Now, despite all the criticism that was directed towards the Nuremberg tribunal or court, it must be admitted that the principles laid down in the Nuremberg tribunal have greatly influenced international law, particularly international criminal law, because the Nuremberg tribunal has been the starting point And from there onwards, states have been continuously making efforts to introduce new principles of international criminal law to ensure that persons who commit war crimes and crimes against peace and crimes against humanity do not escape liability. They have to be punished. And that is why the Nuremberg tribunal is said to be legally very, very significant. Then the laws of war are not only for states, but also for individuals. When the laws of war were made, particularly during the two Hague Conventions of 1899 and 1907, two landmark conventions signed at Hague, even the laws of war were discussed. So the laws of war are not exclusively for states, it is for individuals because individuals together constitute a state. States do not commit war crimes, it is the individuals who commit war crimes. So that is why the laws of war are not only made for states but also for individuals. Therefore, by punishing the individuals, the rules of international law can be properly and effectively enforced. So this is my submission as far as the Nuremberg Tribunal is concerned, or the Nuremberg trials. Thank you very much.
Oh, thank you, Professor Dr. Sripathi. That was very erudite and very comprehensive. I think the viewers will agree to that. Now, I'll proceed to touch on a few areas before we could get Councillor Brian to say what he would like to contribute towards the discussion today. So, as I said, Professor Dr. Sripathi has really comprehensively dealt with the issues relating to the Nuremberg trials. I just wish to point out that the international military tribunals were as a result of a number of processes that took place, just as the professor indicated. One of the major developments that we wish to point out is the formation of the United Nations War Crimes Commission, the UNWCC, which was set up on the 20th October 1943. It's important because it provides the background against which we are able to analyze international military tribunals. As we shall see, not just the Nuremberg Tribunal, but as well we had the Tokyo Tribunal, which the professor touched on. So what is it about the United Nations War Crimes Commission? What was its purpose? The cardinal function or primary responsibility of this commission was to be a fact-finding body, also to perform advisory functions for those members of that particular commission for the development of the principles of international law and planning for international tribunals. Therefore, it follows that the United Nations War Crimes Commission was formed basically and essentially to collect, investigate, and record evidence of war crimes and to identify where possible the individuals who are responsible for the commission of these crimes. However, it is critical to note that the United Nations War Crimes Commission had no power to prosecute the suspected war criminals and could only report back to the United Nations members of that particular commission. It was therefore incumbent upon the governments of the member states of the United Nations War Crimes Commission to convene a tribunal, such as the International Military Tribunal of the Nuremberg, which would therefore prosecute the person suspected of committing those crimes. So against the backdrop of that analysis, it is important, I'll be able to deal with one other aspect, a technical aspect, which is the jurisdiction of both courts, the International Military Tribunal of Nuremberg, and compare it with what we have at the ICC at the moment. So as I said, essentially, something that is important to recollect, we had two tribunals. Just want to narrow down very fast on the Nuremberg Tribunal. Nuremberg, because it was based in London, in Germany. That Nuremberg is in Germany. And of course, the professors very ably outlined the background and all the subject matter relating to the formation. We just wish to indicate that the Nuremberg Tribunal was a product of victory in war. What does that mean? It means that essentially when in the early winter of 1942, the governments of the principal states, that's the USA, the Great Britain, France, and Soviet Union, who emerged victorious later in the Second World War, they announced what the professor indicated as the Palace of St. John's, at the Palace of the St. John's, where they indicated they would be able to prosecute and punish the Nazi war criminals. The focus was largely on the crimes that were committed, the war crimes that were committed in the state of Germany by the German Nazi regime. It was not Germans as a whole, but a particular clique who were in government at that time, the Nazis. That Nazi government pursued and intensively ensured the success of the policy of aggression. And this particular policy was condemned roundly by all these powers and other civilized nations. So another critical point that I need to bring across is that people, the international community, the civilized community, began to recognize the need for an organized form of international criminal justice to enforce international criminal law at an international level. That's a very, very critical achievement of the developments that emanated from the evolution of the international military tribunals, notably the Nuremberg Tribunal. There was therefore need to mete out justice for criminal offenses. And therefore, of course, that raised the issue, which I said I would deal with, the issue of the technical issue of jurisdiction. That raised competition between national jurisdiction and international jurisdiction. So it brought into fore the issue of distribution of juridical competence between the national and international jurisdictions. And it's clear that at that point, the concept of complementarity did not arise. It does not feature at all at that point. All right. So where we had now, how does this competition come about? Where we have competition in terms of the distribution of juridical or jurisdictional competence, for that matter, which jurisdiction would be competent to handle a matter. In other words, we're asking which states, would it be an international community to deal with it, or would it be the responsibility of the national jurisdiction to prosecute its own criminals? But we know, obviously, that given the Nazi nature of operations and government, they were not going to prosecute their own kind for crimes that were committed by they themselves. So this necessitated the involvement of the international community. And therefore, when the competition came, the favor was for an international approach. The jurisdiction would have to be conferred upon an international arrangement or framework to be able to ensure a proper administration of justice and administration in terms of punishing the offenders at an international level. All right. Another critical point that I would want to bring in relates to the declaration that the professor talked about, the Moscow Declaration that was signed by the three main powers. That's Britain, the British Prime Minister, Winston Churchill. We had the Soviet Union leader, Joseph Stalin, and the United States President, Franklin D. Roosevelt. The essence of that particular declaration, when that armistice was signed, persons who are deemed responsible for war crimes would have to be returned to those territories which the crimes have been committed. It still underscores the very point that I mentioned about the issue of competition in terms of jurisdictional competence to try these kinds of crimes. So we can see on a more broader perspective, from an international law perspective, it brings in the issue of nationality principle in international criminal jurisdiction. And in essence, it actually served to emphasize the primacy of national jurisdiction in that essence. But as I said, it was, you see, they had, this was the view that whoever committed crime would be taken back to where those crimes were committed, assuming they had run away from the point. But given the nature of the circumstances, nature and circumstances around the commission of these crimes by the Nazi regime, it was critical that a framework would have to be evolved that would effectively handle the prosecution as well as the investigation, of course, prior to the prosecution of these crimes, to ensure justice for the victims, and also to mete out justice as an indicator to the rest of the world that there should be deterrence for the commission of such crimes. So we are dealing with jurisdiction still. So the issue of allocation of jurisdiction. In fact, there are arguments also among some of the leaders that apart from just the trial process, there are those who had argued that some of these criminals or suspected criminals should just be summarily executed. But that, again, that was overwhelmed. That line of argument was overwhelmed by those who argued that they should be subjected to a trial process, and when found guilty, would have to be punished in a formal way, depending on the laid out framework. So much as certain political leaders advocated for summary execution, as I've said, of the Nazi war criminals, they were subjected to proper trial by the Allied powers. Although, albeit, of course, those who were trying were the victors in the war that just ended. So as a consequence of all that series of events, as the professor indicated, we had the 1945 London Agreement, to which it was annexed the Charter of International Military Tribunal, that's the Nuremberg Charter, was annexed to it. And that's the charter that provides for the functioning, authority, and the procedures, the trial of war criminals or crimes that were indicated within that particular charter. So it is critical to mention that the International Military Tribunal of the Nuremberg represented the genesis, the beginning, the essence of the international criminal law. The Nuremberg trial had a significant impact on the development of international criminal law. That is very important to remember, including issues, just as I've said, of distribution of jurisdictional competence between the national and international tribunals. This particular one in the current state, presently, this issue is dealt with when dealing the issue of complementarity, the principle of complementarity, where we have certain challenges against complementarity at the ICC. That is the corresponding argument that we have contemporary at the ICC. So the IMT, that's the International Military Tribunal of Nuremberg, presided over the joint trial of senior Nazi political officials and military authorities. Essentially, actually, most of these criminals were powerful politicians, and most of them, the others were military personalities. And so, as already narrated, I don't have to go on through that. All I have to say is that on the 18th of October, 1945, 24 top Nazi political and military leaders were arraigned before the International Tribunal of the Nuremberg. And among those who are charged, we have people like Hermann Göring, Rudolf Helf, Joachim von Rieck, Alfred Rosenberg, and Albert Speer. But interesting, the orchestrator of all this, the main brain behind all this violence the Nazi military dictator Adolf Hitler, avoided the indictment by committing suicide, allegedly in April 1945. So that was during the final moments of German surrender to the Allied forces. And which crimes? There are four main crimes that, or charges that were brought against the Nazi officials, as the professor has already indicated. I just want to, emphasize on them. So these officials were arraigned before the Nuremberg tribunal for the war crimes that they were suspected to have committed, crimes against peace, crimes against humanity, and conspiracy to commit each of those three crimes. In other words, conspiracy to commit war crimes. There are those who are charged also with conspiracy to commit crimes against peace and conspiracy to commit crimes against humanity. There isn't much I can add on to that, but just to indicate also that the trial did last about 1 year. That's from November 1945 up to October 1946. The date I mentioned, 18th October 1945, it's critical to distinguish that. That date is when the suspects were arraigned before the tribunal. They were arraigned in respect of the charges, but the trials began right in November and ended in October 1946. So to summarize, the essence of my discourse is to underscore the critical importance in terms of a technical issue of the distribution of jurisdictional competence that emerged as an important factor in all these proceedings, whereby there was competition between national jurisdiction and international tribunal jurisdiction, and which jurisdiction was competent to be able to undertake the trial and proceedings relating to the suspects. And on that note, I wish to say thank you for listening. Thank you, my fellow panelists, and thank you, our viewers, for listening. I am Professor Dr. Milton, as we said, and now I hand over to any of my colleagues who may want to contribute to the discourse. Thank you very much.
Thank you very much, my learned professor. One of the things that I wanted to note during the Nuremberg trials is the legal principle, one of the cardinal legal principles in criminal law, the presumption of innocence, because other states were arguing that they should not go to trial and just be executed. So that's one of the cardinal legal principles that with time grew, in which it's one of the, it derives from the principle of giving an accused a fair trial before or undergoing the process of a fair trial before the accused can be convicted of a crime. That's one of the issues that I wanted to put out. Secondly, I wanted to give a submission on the issue of national jurisdiction versus international jurisdiction. It can be a valid argument that if you look closely to the Nuremberg trials, where a lot of convictions were made, because there was no competition between national jurisdiction and international jurisdiction, because the issue of complementarity did not arise. But as time goes on, we have seen that the issue of complementarity has arisen, and it has led to less convictions of in the international criminal court. Perhaps one may argue that the principle of complementarity has been used by other states because of obviously the reluctance by other states to hand over their warmongers or hand over their leaders to the International Criminal Court. So that on its own can be an argument to say that it has been used to protect those warmongers or those leaders. Because where national jurisdiction and international jurisdiction clashes, it is going to be very difficult to where the concept of sovereignty now is given reference, or a lot of countries or is given reference by the international community, is going to be very difficult to prosecute and convict those war criminals who are accused of committing international crimes. Thank you.
Oh, good questions, Council. I think, Professor, do you want to handle that, or I should deal? I think it deals with some of the areas I touched on.
Professor, if you allow me,
Yes.
Some of the doubts that were raised by our colleague, Brian.
Yeah, you can proceed.
The first question that was rather a doubt raised by Brian is the principle of presumption of innocence. Now, I feel that the Nuremberg trial followed all the essential features of a fair trial, and that includes the principle of presumption of innocence. Because according to this principle of presumption of innocence, the presiding officer, that is the judge of a court, shall not be biased. He should not approach the case with a biased frame of mind. Only when the guilt of the person is proved beyond all reasonable doubt, then only the judge can pass a sentence. But before that, he should not be biased, because appearances can be deceptive. The accused could have a baby face, but he could be the most cold-blooded killer on earth. And on the other hand, a person could have a rugged face, but he could be a very soft. So a judge should never go by appearances, because appearances are deceptive. So he should follow this principle of presumption of innocence till the guilt of the accused is proved beyond all reasonable doubt. And how far the Nuremberg tribunal has followed this principle is debatable, because I was not there at that time. So even the literature that I have read on Nuremberg tribunal has not mentioned anything about the presumption of innocence. So I do not know. What I know is that the judges were criticized because they would be biased. They would be biased because they all came from the victorious powers. That anger and anguish was always there for them, and the decrees of the Nuremberg tribunal were certain that the accused would not get a fair trial. So that is one doubt that I've cleared. Coming to the second one, principle of complementarity. I would like Professor Milton to answer this, because he has his doctoral thesis on principle of complementarity.
That's right. I'm an authority on complementarity. All right. Thank you for raising that. Let's welcome Dr. Marotta to the panel. Hello, Dr. Marotta.
Yes,
Hello.
I have. Hi, how you doing? Hi, Professor.
You can see you're 1 hour late. Maybe your timing over there is been adjusted.
Yes, I have some trouble with the internet with the timing, and I have some trouble with the connection. So, yes.
we have gone almost 1 hour now. Actually, past 1 hour. All right.
Yes. Earlier in the morning, I have some trouble with the accessing everything. The line also went down from my mobile phone, and yeah, yes, I have some trouble with internet connection. I don't know why. Probably too much gamers. I don't know. Since Monday, also we had the same problem. Monday at home, they have in my office. We have trouble. We have to use the other company connection, but it's only for the servers. And yeah, we need to to underline. Yeah.
Welcome, otherwise.
Thank you.
We are in the process of we are concluding the discourse anyway. Council Brian, first, I wish to indicate that the essence of the principle of complementarity revolves basically around the Rome Statute provisions, which you may find under article. You could look at what is relevant here when we talk about competition in the sense that you brought it. You need to look at article 17 and 19 of the Rome Statute. But you have to understand that at the time, the competition, what I indicated was that the issue of complementarity could not arise at that time because it had not even come into, the understanding of those jurists at that particular time of the International Military Tribunal. Complementarity is essentially a product or a concept that evolved as a result of interpretation of what we have within the Rome Statute. In essence, complementarity could be defined as, just to put it in lay terms, it is the International Criminal Court was established as a way to complement, to support the efforts of the national jurisdiction. So complementarity essentially is a product, it evolves from the word to complement. Are you with me? And to that extent, the International Criminal Court, what it does simply complements, supports, reinforces what the national jurisdiction does. In other words, says where the national jurisdiction is not able to avail justice, not able to dispense justice effectively, then the International Criminal Court complements by stepping in to ensure that justice is carried out. The national jurisdiction may fail to dispense justice for a number of reasons. One could be, as we said, it may not be having sufficient infrastructure, may not be competent, may not have competent technical personalities, persons to be able to conduct those trials. There could be also the issue of sham trials. That is where the International Criminal Court steps in. But when we look at it in the light of the International Military Tribunal, there was nothing like that. That's what I said. However, the term competition as was used comes in where you see the jurisdictional competence, the question of whether this person should be tried by its own state became of concern. We are talking about the Nazis. The question was whether the German Nazi regime would competently be able to dispense justice in terms of people suspected of war crimes or crimes against peace, as we saw listed there, rather than having an international tribunal. And we said, of course, the essence of that when we looked at the United Nations War Crimes Commission and the limitations, the impediments it experienced, and the essence of evolution of International Military Tribunal, as well prosecuting, because we know the commission could not prosecute. The important point here was that they had to find a legal framework that was very suitable, that was more efficient and effective in ensuring the prosecution of the suspects of the war crimes that they were charged with. So we are talking about jurisdictional competence. Which jurisdiction has competence to be able to deal with this? Is it the national jurisdiction or the International Military Tribunal jurisdiction? It has nothing to do with complementarity at that stage. Complementarity only comes in the light of the Rome Statute, where the ICC features. In fact, the complementarity at this point is related, as we shall see later. If you go on further with your research, you'll see that when you look at the other tribunals, the Rwanda Tribunal, the International Criminal Tribunal for Rwanda, and all those, the concept of complementarity becomes specific in a given setup, more specifically as defined within the Rome Statute. So really, within the IMT Nuremberg, the issue of complementarity was not there completely. as understood in the context of the Rome Statute, maybe understood in another context. And the competition, as I said, of jurisdictional competence basically is because there are people who raised the issue. Of course, it had no legal backing, who say, no, let's summarily execute these people. That was a military argument. But given the civilized nature of things, the victors decided that, no, we have to ensure that there's a process, the presumption of innocence, as you indicated, and as the professor very ably put it, as a critical point of all these trials. We should subject them to a formal trial process, and only when found guilty, then they should be punished. And that is why, as the Professor Sripathi had outlined, there are those who are charged and convicted of certain crimes and those who are not convicted. So essentially, Council Brian, complementarity would be confined within the limits of the Rome Statute. In that context, we'd understand what it is. And so it does not really apply in this context. It will not even apply because the International Military Tribunal was set up to deal with specific situation in a specific country. And you'll note that there was another International Military Tribunal that was constituted in respect of the Tokyo crimes, as the professor indicated. So the moment they were done with all these mandates that they had, they became functus official. The tribunals were wound up. The military tribunal of the Nuremberg lasted only 1 year, and that after that, it was gone. But the ICC is here to endure forever. It's a permanent court. And that complementarity would have to be a very important feature of that court, because there are numerous issues arising from different nations. And also the issue, therefore, of the competition or competence of jurisdiction of each of these at international level or national level will keep arising each time it comes. But when we analyze it, we look at it in the context of complementarity as a principle. And I don't want to go into another more complex area of it, which is positive complementarity. It would just help to confuse that's a very technical aspect, where positive complementarity means the ICC actually encourages the national states to begin to prosecute their own matters, rather than taking matters before the International Criminal Court. And as the first prosecutor of the International Criminal Court indicated, that the success of the International Criminal Court would not have to be measured by how many cases it has been able to deal with, but by how many cases it has been successful in stopping, not coming, and being dealt with at national level. So to summarize and to end this, complementarity is essentially an issue within that revolves basically around the provisions of the Rome Statute. Thank you very much. All right, maybe you want to raise something else from what me and Professor Sripathi have just made in respect of your questions?
No, he spoke of principle of sovereignty also. Sovereignty of Germany, when its nationals were being tried by the military tribunal. Is that what you meant, Brian? Is it the exercise of principle of sovereignty by Germany?
Hello, sir.
Now, when you mention principle of sovereignty of Germany, isn't it? Because the nationals, the war criminals were being tried by the military tribunal, isn't it?
I can't hear you, Prof.
Can you hear me?
I think Professor Sripathi, I think Brian is not getting you. I can hear you. However, I think Brian.
I can hear you too, Prof.
Yes. I think Brian is having some trouble with the audio.
Can you rectify it?
Councillor Brian, can you hear me?
Yes, sir. This is what I was saying, Prof.
The connection.
This is what I was asking.
So, Prof, I think can be audible now. Try, Prof.
Can you hear me now, Brian?
Yes, I can hear you, sir.
You spoke of the principle of sovereignty. You mentioned
Yes,
principle of sovereignty of Germany, isn't it? Because
yes,
the
sir.
war criminals were being tried by the Nuremberg tribunal. See, now
Yeah.
the matter had been domestic, and if they're being tried by an international tribunal, then the principle of sovereignty comes. But here,
Yes, sir.
the state of Germany crossed all limits imposed by international law. There were international issues, international crimes were committed by Germany during the Second World War, not against just one country, but several countries. And they were accused of committing the gravest of the crimes the world can see. So that is why the Nuremberg Tribunal, the judges of the Nuremberg Tribunal had kept aside the principle of sovereignty, saying that the state of Germany cannot claim principle of sovereignty in the light of the kind of uh, crimes that were committed by the German armed forces. And of course, not all of the German army personnel were held guilty. Only those persons who were holding important positions in the army, 10 of them were sentenced to death because they were the ones who had given orders to commit the crimes. And of course, they had to take orders from another superior officer in the armed forces. So that chain continues. So the Nuremberg Tribunal had set aside the principle of sovereignty, saying that Germany cannot claim principle of sovereignty because of the gravity of the offenses that were committed by the uh, military personnel of Germany. Okay. Does that clear your doubt, Brian?
yes, yes, Prof.
Anything more, Council?
No,
You okay?
I don't have any further
All
questions.
right. Thank you very much for those brilliant questions. Dr. Marotta, we are almost
Yes.
winding up. Did you have something for us? I know
Yes, I
you are
want
the
to
one
add
who raised
something
this
for
particular topic. You must be having something.
Yes, I have something to add for the question that I couldn't hear before because I have trouble with the internet. It's for
Yeah.
Brian. Brian, you need to. I have something here that will broad your relate to what Professor Shripati has said. Um, you need to take a look at Radbruch. There is a Radbruch formula. Radbruch propounded the notion that positive law must be regarded as contrary to justice and not apply where the inconsistency between statute law and justice is so intolerable that the former must give way to the latter. There is a case in Germany that is Stressless and Kessler that was in October 24 in 1996. And the court says the court dismissed the defendant's submission. Among other things, it's noted that the prohibition on retroactive law derived its justification from the special trust reposed in criminal statutes enacted by a democratic legislature respecting fundamental rights. So as Professor Shipati has explained, in this case, the criminal code of the German was against all humanity. I mean, it was a very enemy criminal law. So in this case, the principle of this humani generis. So under that conception and the Rashid formula that it is from it helped for building the Nuremberg rules and rulings, they decided that the most important here was we need to is the natural law before anything that has been written, because the Germans were advocated that crimes when were committed they weren't recognized by the statute law, but that was considered totally insane because we need to prevail the rights of the human beings. So that was the idea. So I will send you by email. I think it was in the book of Professor Cassese that is titled International Criminal Law, that you will find a site related to Radbruch and that can give you some enlightenment for your research. So also the paper of Professor doctoral thesis that I have read it. He only told me that I have to read from page 21 to from
Oh,
22 to
yeah.
yes, but I read all, but I finished reading all your doctoral thesis. Is very interesting. I mean, it's a very. I recommend you, professor, that this your doctoral thesis need to make a book. I mean, because it's it had a lot of.
Yeah, it's already published in form of a book. It's available on
Yes,
Marking
you need to do
Online.
that, professor. Yeah, because
Yeah,
it's
thank you
very. I
very
mean,
much.
it's very useful for. I mean, for practitioners, it's a very good guide for
Thank you,
practitioners,
Doc.
international practitioners, and for students. I mean,
Yeah.
also, I hope Professor Shipati can also share his research because now it's very important because we have more time for reading under
Yeah.
under this COVID-19 situation. Yeah, and I mean, it's going to be prolonged. Here in
That
Peru.
is true. That is
Yeah,
true. There is
have more time
time.
for
There is time for us to leisurely work on things.
yes, and also I mean also for I have some friends that are teachers, university professors, and also they have more time because they are having their lessons through reaching their students through Zoom or other applications. So I mean, it's going to help a lot for research. Yeah, I want to add that because, that the Radford formula that was very used, and in the book of Professor Casese, you will find. Professor Casese passed away last year, if I'm correct. Yes, or was the year before, but he died uh, very shortly. But
Yeah,
yeah,
we
no, it's a
have
very
the
good
book.
research.
We have the
Yes,
book in our
it's a
library.
very
Antonio
uh,
Cassese. Yeah.
yes. Yes, Antonio. Yeah, it's a very. It's one of the of from my favorite books. Now the second favorite research paper is from Professor Milton. I mean, it's very, and all the all the reference that that you made, Professor, in your book are well, it's very important. I mean, it's a very good document. And as I told you, need to knock the door for a publisher, and you can also have it in Kindle or other application, hard copy, and that's going to be very useful for students.
It's already published actually in
I
Germany.
like your shirt. I like your shirt, Professor.
Oh,
it's very
thanks.
nice.
Thank you very
Yes,
much. I wanted to
yes, it's
be
very yeah,
casual
yeah.
today.
Yeah, yeah, you are
Nice to
more
have you after a
like
while. We thought you
summer.
would show up.
Yes, yes. No, because I have this trouble with. I mean, this week I don't know why here in Lima, there have been trouble with mobiles. All the companies they're here like four. Oh no, it's three company or four companies that they provide you with mobile internet, and they all collapsed. This week it was very terrible, and next week there is another company that's going to provide the service. I think
Is
they're
that as a
going
result
to
of the
spread.
political turmoil that we are watching every day?
Yes, here, yes, here is we have. What happened here is that in this country I have seen four presidents passing through, two impeached, the other one resigned, and this one we are crossing fingers that he can stay
Was too hot.
for the elections. Yes, the elections are going to be next year, but yeah, I mean, I probably something something about that.
Yeah.
That we don't know that there is a lot of misinformation, and also they made something strange. They also this new Minister of Interior made something very crazy because according to the law of the police in Peru, you cannot retire only if you want to change, and there is a final ruling of the constitutional tribunal from Peru that only you can pass to retirement only like seven or four or like seven in the police force, seven generals, and this new administration have passed like 14, and there's a chaos. The police force is very very sad under this situation, and they will go to they're going to go to a national strike next week, and that's going to be very crazy, because I was doing some research here, and back in the 70s, it was, I don't know, it was in 74 and 75. You can research that on Google, and there was also, they did the police force here in Peru, they did a national strike, and it was a disaster. The military have to enter, and when military enters, it doesn't have a very nice ending. So we hope that this new administration can make in the pace the changes, correct that, because it's not also if they don't do the change, there are going to be a lot of trials of these generals before the courts here, and also in the Inter-American Court of Human Rights, because there is a case in I don't know if it was in Uruguay or in Argentina that the Court of Human Rights ruled in favor of also these generals. They were from the police force, and they were they need to the Inter-American Court, they said that they rule against the law, and they need to be they need to go back to the force. So probably will happen that we are crossing fingers that between these days the administration, this new administration, can do something, because it's the political situation here is very, with this new president Sagasti, all cooled down, but now once again the turmoil is getting, the tide is getting high again. So it's very, and also here also in the south, in Chile also, it's once again, even though they are going to have a new constitution, once again there are the strikes on the streets. So yeah, also I don't know if you saw what happened in Central America, that they burned their parliament in Guatemala. So yeah, the situation here in Latin America, from Mexico to Argentina, it's it's very, it's changing every 24 hours.
So thank you,
we don't know
Doc. I think that has been.
Thank you.
Thank you for
Professor.
the presentation and that good update on the issues in Latin America.
Yes.
It was nice having you on the panel again. Sir, I think our time is up. We want
I have one small clarification.
Yes. We still
Tend to clarify.
Yes, Prof. Just proceed.
You have, your doctoral thesis on positive complementarity.
Yes.
And just earlier, you had mentioned that positive complementarity is where the ICC encourages the states, the national jurisdiction, to try the criminal first under the national criminal law. And only where the state is not in a position to try or is unable to punish, then the ICC steps in. Complementarity is the ICC encourages.
No. It's a very technical. Those terms are too technical and very, a lot of confusion arises out of them. Complementarity, actually, if you look at the Rome Statute, the term complementarity is used only within the preamble. If you look at the preamble, it's a term which was coined by the drafters, those who sat when drafting the Rome Statute. Complementarity does not exist as a word anyway in common parlance in any of the, if you check the dictionaries, it would lead you to something else. But it emanated from the term to complement. So there's the cardinal principle of complementarity. That's the original principle. That's the principle which is within the Rome Statute. You know what I mean? In the context of that principle, there's positive complementarity and there's complementarity. In respect of complementarity, the ICC shall only step in to deal with that issue, which could have been dealt with by the national jurisdiction if, just a minute. Yeah, Brian, you are free. We are done. You are free to leave. We are leaving in the next 1 minute. So complementarity is within the context of the provisions of the Rome Statute, meaning the International Criminal Court shall only step in where the national jurisdiction, for one reason or the other, would not be able to dispense justice, either unwilling or unable, any of those circumstances that are listed within the statute. Positive complementarity comes in later. It is actually a policy that emanated from the OTP, the Office of the Prosecutor of the ICC. It is the Office of the Prosecutor of the ICC that came up with a policy to be able to, to have a positive approach. Initially, it was a positive approach towards complementarity. And so it became a policy of positive complementarity. Under this particular policy, unlike complementarity as a principle, the prosecutor or the International Criminal Court would have to encourage, without necessarily, if you look at the definition that was provided at the Kampala Review Conference, you need to look at that definition, the Kampala Review Conference, what they provided in terms of what positive complementarity should be. There's no universally accepted definition of it, but the tenets of it, as you see in my doctoral thesis, I argue that really up to now, there's no clear tenets of each of these provisions. I mean, what positive complementarity stands for. There's no universally accepted, points that we point at and say this is what positive complementarity is, but there's a consensus of what direction it takes. It is to encourage the national jurisdiction to be able to, carry out the investigation and prosecution of crimes on its own. In others, enabling environment, creating an enabling environment for these national jurisdictions to be able to carry out investigations and prosecution, as opposed to complementarity as a principle, which insists that owing to the primacy that the national jurisdiction has in terms of prosecuting and investigating, the ICC shall only step in where there's manifest inability to be able to prosecute or to investigate, or unwillingness for that matter. So that is how I can address the issue that you've just raised. It is very detailed. You can see it from the essence of my, the whole doctoral thesis. It's a very, very detailed discourse on its own.
The Rome Statute speaks of the principle of complementarity.
Yes.
But this positive complementarity, you say, is an offshoot of the Office of the Prosecutor.
Correct. And there's argument that actually there are some provisions of the Rome Statute that have been interpreted to say it gives credence to that kind of reasoning of positive complementarity, which is debatable. A lot of debates around that.
Yeah, because we can say there could be negative complementarity if there is.
That's interesting. Yeah, it has been argued in that form. Jurists have been arguing about it as well. That if we have positive complementarity, we should also have negative complementarity. But you can look at it as classical complementarity. There are instances where the principle of complementarity is referred to as classical complementarity. Then we have the positive complementarity, the newer view of what complementarity should be. It's an endless discourse. There's no end to it.
Yes.
All right. Thank you very much.
I should thank you for clarifying my doubt. Thank you very much, Professor Milter.
Thank you, Professor Sripathi. And I wish to thank the panel. Thank you, Dr. Marotta, for being there today. Thank you, Professor Sripathi. Dr. Marotta, you just missed a very, very comprehensive presentation by...
Yes, I will see it again.
Followed by Dr. Professor Sripathi on the topic. And we thank you, viewers, for being there to be able to attend to this discourse. We hope to see you again at a date that shall be announced. Thank you very much. And bye-bye, everyone.
Bye. Thank you. Have a nice
day.
Bye.
Bye.